Washington versus Glucksberg came before the United States Supreme Court when Dr. Harold Glucksberg, 4 other physicians, 3 terminally ill patients, and a nonprofit organization challenged the state of Washington's ban on physician-assisted suicide. The question presented in this case was whether Washington's prohibition violated the 14th Amendment to the United States Constitution. At the Supreme Court, Dr. Glucksberg and his co-plaintiffs asserted that the 14th Amendment's Due Process Clause protected the choice of a mentally competent, terminally ill adult to commit physician-assisted suicide. The state of Washington, on the other hand, argued that its compelling interest in preserving the lives of its residents outweighed this liberty interest. In a unanimous decision, the Supreme Court held that assisted suicide was not a fundamental liberty interest protected under the 14th Amendment, and Washington's ban was allowed to stand. The majority opinion, authored by Chief Justice Rehnquist, determined that fundamental rights are identified through an analysis of the United States history and traditions and must be implicit in the concept of liberty. Suicide and assisted suicide have consistently been considered a violation and a crime throughout the nation's history, Justice Rehnquist found. Therefore, the court concluded that this liberty, the right to die, was not protected by the 14th Amendment's Due Process Clause, even if other important, intimate, and personal decisions were. Moreover, the state's interest in preserving life fully justified its ban on physician-assisted suicide. The court's ruling in Glucksberg provoked strong criticism from many. Detractors argued that the Supreme Court's rulings on issues of privacy and autonomy were murky, inarticulate decisions, likely to be very imprecise about the bounds of one's right to end one's life. Others lambasted the court and states for prolonging the suffering of patients. Questions surrounding Glucksberg remain unresolved. The state's interest in preserving life manifests on other polarized issues like abortion, and the court's formula for determining fundamental rights has cropped up in more than a few decisions since. The most consequential response, interestingly enough, came from the states, since the court's decision deferred to the democratic process regarding the question of assisted suicide. A significant fraction of states took it upon themselves to pass legislation. Before Glucksberg, Oregon was the only state that had legislation permitting and regulating the practice. Today, 10 states and the District of Columbia have legalized physician-assisted suicide with protections for persons themselves.